Constitution. My Lord, Ground 5 accused the Deputy President of grossly violating Article 3(1) and 148(5)(d) of the Constitution and of failing to uphold his oath of office and allegiance. There were no details provided. Instead, Ground 5 simply referenced Ground 1, 2, 3, and 4. This unfair and confusing charge was such that even though the Senate cleared the Deputy President of Ground 2 and 3, it still voted to impeach him based on Ground 5. There was no attempt to explain, even vaguely, how the Deputy President had violated his oath of office. Ground 6 equally alleged that there were serious reasons to believe that Brigadier Gachagua had committed crimes under Section 13(1)(a) and 62 of the National Cohesion and Integration Act. As I mentioned, my Lord, and I now put this on record, why wasn't he taken first to the National Cohesion for prosecution before invoking the last resort remedy of impeachment? Because the Deputy President filed a response to the motion before the National Assembly on 8 October 2024 and was granted 2 hours to orally present his rebuttal on the floor of the National Assembly from 5 p.m. to 7 p.m. In the presentation, the petitioner made a cogent, irrefutable, factual, and legal response to each of the 11 grounds cited in the impeachment motion. Lord, you see that in Exhibit RG2, Volume 2, pages 211 to 240. For instance, concerning the claim in Ground 8 that the Deputy President had acquired property and wealth estimated at 5.2 billion Kenya shillings from proceeds of corruption and money laundering, the Deputy President explained that no valuation had been done, so where the National Assembly, Honorable Mwengi Mutuse, got 5.2 billion is anybody's guess. If you want to charge somebody, you present evidence that this is the value of this property. Further, from his brother's will, the bulk of those properties to which the sum of 5.2 billion was erroneously and maliciously attached belonged to his late brother, the late Honorable James Derito Gachagua. May his soul rest in eternal peace. Some, like the Olive Garden Hotel, Vipingo Beach Resort, Queensgate Serviced Apartment, he did not even own. And yet, this was what he was impeached on. But we are falsely attributed to him. He produced ownership document showing otherwise, and you will find that, my Lord, in RG2, Volume 2, pages 211 to 214. Lord, although the mover of the motion listed that the 2 companies associating them with the petitioner, first petitioner,
alleging that they had been used to massively launder money and conceal proceeds of crime, of corruption, and benefit from influence peddling, there was not a scintilla of evidence to support or prove those allegations. No evidence showed any impropriety, and you will find that in RG 2, Volume 2, pages 214 to 218. The Speaker of the National Assembly, again, a good professional colleague who I respect, did not direct the members to the threshold test, the appropriate standard. Hence, the resolution was passed in proceedings conducted as a vote of no confidence, rather than a critical step in impeachment proceedings to alter the sovereign will of the people. And you'll find that as message of the Senate, number 025 of 2024, approval of special motion, RG 3, volume 6, 745 to 745. Equally, the National Assembly's decision of 8 October 2024 was invalid on the grounds that, one, the impeachment motion was replete with the general unsupported allegations, hearsay, and outright lies, and lacked particularization and specificity required by Article 145(1) of the Constitution of Kenya and Standing Order 64(1)A of the Standing Orders of the National Assembly. 2, members of Parliament debated and voted on the motions on grounds other than those set out in the motion. The impeachment was converted into a vicarious assault on family rather than investigation of constitutional violations by a public servant. Members of Parliament, let me skip that and go through the next one. The entire impeachment process was designed to avoid and be ring-fenced from scrutiny and accountability, pushed through with uncharacteristic speed, with the intention of ramming the process through before it could be audited for constitutional compliance. The National Assembly prosecuted proceedings on the basis that the petitioner offended the President rather than the Constitution. What the 2010 Constitution provides is violation of the Constitution. In other words, the President must take time and choose his deputy. My Lord, I don't need to take time to go through what the country was put through between His Excellency Daniel Toroitich Arap Moi and his Vice President George Saitoti dangling the Vice Presidency, requiring the President to choose his or her deputy before the election so that the people could themselves vote is a very important aspect of our Constitution. The National Assembly trivialized the gross misconduct standard set out by the Constitution and other statutes for holding public servants to account. And, my Lord, I will not repeat the Bambara case, but I would state the impeachment motion was replete
with generalized statements, unsupported allegations, hearsay, outright lies, lack of particularization and specificity, as required by Article 145. My Lord, the exposition on all that is set out in paragraph 36
of our written submissions, and I will not take the time of this court going through them. I invite the court to read through it when you retire. Despite this glaring and fatal flaws apparent on the face of the motion, even on a cursory review, soon after the impeachment motion was tabled in the National Assembly, the first respondent issued a communication from the chair, number 46 of 2024, in which at paragraph 16, 18, and 20, he stated that he was satisfied that all the grounds in the impeachment motion met the requirements of the threshold under the Wabora case. The first respondent legally incorrect decision to allow the motion to proceed for debate, despite its clear failure to meet the specificity and accuracy requirements of the standing orders, seems to have been motivated by Parliament's biased and reckless haste to pass the motion as quickly as possible in order to shield the process and its obvious serious rules from judicial review. It is our submission that that was the real reason for the rush. My Lords, Article 50, Sub-Article 2B of the Constitution states that every accused person has the right to a fair trial, which includes the right to be informed of the charge with sufficient detail to answer, to be informed in advance of the evidence the prosecution intends to rely on, and to have reasonable access to that evidence. The motion thus violated Article 50, Sub-Article 2B, and Article 50, Sub-Article 2J of the Constitution by setting out vague allegations, criminal conduct, including the Deputy President had violated and repealed sections of the penal code, the leadership and integrity without ever charging it. Overall, the impeachment motion of the first respondent's communication from the chair was thus incapable of invoking the National Assembly's mandate under Article 150 as read with Article 145. My Lord, you will see all that in RG 1, Volume 1, pages 2 to 41, and RG 8, Volume 7, page 969 to 976. So, my Lord, that is all I wish to say about A. Let me very quickly move to C. My Lord, issue C is there a problem with your gadget? Say hold on. I'm listening to the My Lord, issue C is whether the Senate.
Do I need to remind you about time?
Only another 10, 15 minutes.
You have here 5 minutes.
Yes. Yeah. Moving as quickly as I can. See, my Lord, which you find at page 40 of our submission, is whether the Senate, misled by its misinterpretation of Article 145, rushed the process and denied the Deputy President here. The Senate, my Lord, recognizes the right to a fair hearing in considering a petition for removal of a person from office, because they say so in their standing order number 81, the right to appear before the committee, the relevant committee. That is in standing order number 81. Whenever the Constitution or any other written law require the Senate to consider a petition or a proposal for the removal of a person from office, the person shall, and the word used in standing order number 81 is that the person shall be entitled to appear before the relevant committee of the Senate. The petitioner here was denied that opportunity to appear before the committee. And the importance of the committee, my Lord, is that the committee has got less members. The law gives the subcommittee 10 days to investigate. And therefore, the deputy president would have been able to appear before that subcommittee with his evidence, with his lawyers, and would have been able to argue. By bypassing the setting up of that committee and assuming that the 10 days related to the plenary, which they did not, the deputy president was denied a fair trial. Lord, when the deputy president had all along appeared in person and signaled his willingness to take the stand, he became mute. And all of us are human beings. Lord, illness does not come knocking. One is just taken ill. And he was taken ill after very stressful, strenuous proceedings, National Assembly, and the first day in the Senate. Lord, it's a very stressful situation for the deputy president to be deprived of that position to which he had been elected by over 7 million people. Lord, when counsel for the deputy president stated that he had been taken ill, the speaker ruled for the Senate, I said we were going to execute with military precision owing to the fact that we need to conclude business today. And he said I had indicated that I could not get hold of the client or the doctor's advice because he had been admitted to ICU. Lord, first, the 10 days did not apply to the Senate. That was a misreading of the Constitution in the law. But secondly, there was time we were requesting adjournment up to Tuesday to see about the deputy president improvement.